everybody. Welcome. I'm really delighted to be able to introduce Judge Mark W. Bennett, who is a senior district judge for the United States District Court of the Northern District of Iowa. He was appointed to the bench in 1994 after having served as a magistrate judge in the Southern District of Iowa. Before that, he was a very successful litigator, practicing employment discrimination, constitutional law, civil rights, and criminal defense. He had 3 petitions for certiorari granted by the United States Supreme Court before he was 35, which is a really remarkable achievement. Barring from another introduction of him, he sued the President, the Pope, and the 9 justices of the Iowa Supreme Court in a 30-day period, and he won all 3 cases. He is a prolific scholar, having published law review articles on a wide range of topics. Among many other things, he is a nationally known expert on implicit bias. I first met Judge Bennett when he gave a talk on implicit bias at a workshop for law school deans. I was tremendously impressed. I learned a lot. He was a great speaker. I immediately went up and invited him to talk here, and it turned out that he had already been invited. If you add the invitation to Judge the Fornoff round, he's now been invited 3 times for his visit with us. And I'm very glad that he's here with us today. So please join me in welcoming Judge Mark Bennett.
Thank you very much, Dean Barros. It's a real honor to be at the real UT, not the one in Austin or Knoxville, but the one in Toledo. So I'm very passionate about this subject, and thank you all for taking time out of your busy day to come hear my lecture. So last night after dinner, I decided to look up Ohio incarceration rates, and this is 2017 data. I'm colorblind, but that middle bar that goes up real high, it's either orange or red. Those are black defendants, offenders incarcerated in Ohio prisons, not jails. The blue is the white, and the Hispanic is the gray. As bad as this looks, Iowa's is much worse. It's almost identical with regard to the blue and the gray, but our red bar, or orange bar, is 50% higher. Iowa's actually used to be the worst state in terms of incarceration rates of African Americans. Now we've moved up to 46, not much progress. So 2 years ago, it was late May or early June. I was at home on Saturday reading my pre-sentence reports because you'd think the Northern District of Iowa would be a really light district for crime. We have the 6th heaviest criminal caseload in the nation, and I'll sentence in a typical year about 5 times what the average federal judge does in the country because we're in the methamphetamine pipeline. So I was getting ready for the sentencings of the week, and I was listening to President Obama giving the commencement address at Howard University, and then this is what he said. And so it really caught I was just listening kind of out of one ear, and when he said, might have unconscious biases, as we all do, that really caught my attention. And it took about 2 hours before they posted his speech online because I wanted to make sure I heard it correctly, and I did. So when the president is talking about implicit bias or unconscious bias, you know we've come a long way. Unfortunately, I think the Attorney General and the Vice President, current Vice President, don't believe it exists, so we've got a lot of work to do. So my daughter, who when she was 13, she turned to me and she said, I was talking about, she was supposed to have come to the federal courthouse to watch one of them. I was having a fascinating trial, and she never showed up. And so at dinner I said, Sarah, why didn't you come to the courthouse today? And she looked at me and she said, Daddy, I know it's hard for you to believe, but I'm not interested in what you do. To which I broke out laughing because that's the beauty. She doesn't have to be. She's an artist and picked out this tie for me. So, but she came up with an idea for me because she's really interested in the implicit bias stuff that I do. So she sent me a slide and she said, Dad, if you only could use one slide to talk to people about implicit bias, I've got the best slide for you. So here it is. And here's the punchline. One of them went to a federal prison and was convicted of a federal crime, and it wasn't Snoop Dogg. And so that's I'm done now with my presentation. You've got it. I can walk off the stage, you understand implicit bias. So just start with a simple definition. Generally recognized, it's automatic instant association of stereotypes or attitudes towards particular groups, and we're not consciously aware of them. So this is something, I'll just let you read the slide. This is something that's really difficult for people to understand, particularly lawyers and judges. Most lawyers and virtually every judge I know, they're very egalitarian in their beliefs, and I think law students are too. Probation officers are. We have some probation officers here, municipal judges. They're all hold deeply egalitarian values. But you can have deeply egalitarian values and also have a lot of implicit biases. As a matter of fact, in a lot of studies, they're inversely related. Your lack of explicit bias actually, it's not what causes your increase in implicit biases, but there's a reverse relationship. So this is talking about stereotypes, because that's an important part of implicit bias. So what do you think his hobby is? Would any of you, if I had you write it down, say opera, singing? Probably not. I had a great experience with stereotypes this summer. I was in a wheelchair from a complicated ankle surgery at the Mayo Clinic. I was in the wheelchair June, July, and August. And I was feeling a little bit better in July going into work. And so I go into work very early, usually between 4 and 4:30 in the morning. And there are very few restaurants that are open that time, and I wanted to stop and have breakfast. And so I had real trouble getting into the booth, and but I finally got in. I ordered my breakfast, and I was getting ready to leave. And a motorcycle gang fellow walked in, and he had El Forastero patch. And it's a kind of a local motorcycle gang. And about 15 years ago, I put the top echelon of that gang in prison. Most of them received life sentences. They were convicted of a continuing criminal enterprise. And there aren't many El Forasteros left. And so this guy, but several of them got lengthy sentences short of life. And so when this guy walked in, I saw the El Forastero patch, and I thought, uh-oh, I hope he doesn't recognize me. So he sat right directly across from me, and when I was getting ready to leave, I was having trouble getting out of my booth into the wheelchair. And this guy was tough looking. I mean, rough and tough. And he leans over and he says, "Excuse me, sir, could I assist you in getting into the wheelchair?" The last thing in the world I thought he would say, and he did, and I was profusely thankful. And then came the punchline. "You look familiar to me." And I said, "Oh, I get that all the time from people, but I'm sure we've never met before." But there was my stereotype. I thought he'd be the last person in the world that would help me. Not only was he the first one to offer, but he was so gracious in how he did it, not kind of what you would expect from a stereotype. So you and the IAT, how many of you, the IAT stands for Implicit Association Test, and it's an online test that you can take. I'm just curious in the room, how many have taken an IAT? Okay, well, that's a good response. How many of you, when you took one or more IATs, were surprised at the result that you obtained? Yep, okay, well, about half the hands went up. So I want to tell you my experience with an IAT. So my mother died when I was very young. I was raised by, I call her my second mother, an African-American woman. Had no romantic relationship with my dad, but she came in and helped raise my two brothers and I. And from a very early age, because of discussions with her, I wanted to be a civil rights lawyer, and that's what I did. And then when I started my own practice, the first lawyer that my two partners and I hired was an African-American assistant U.S. attorney, and he was my partner for a dozen years. And then he became U.S. attorney when I became a federal judge. Think of it, two people out of this really small firm. And then a couple years after that, I had the privilege of swearing him in as one of the very few African-American state court judges in Iowa. And in most of my practice, I represented African-Americans, so I have a great fondness for African-Americans. I've taken every explicit test imaginable on race, and I always have zero explicit biases. So I was teaching a course in employment discrimination with the assistant dean at Drake Law School, and this was about 12 years ago, and I was there for the first class, and he asked me, he said, "Mark, have you ever taken an IAT?" And I said, "Russ, I have no idea what you're talking about." So he explained it to me, and I thought, oh, that's great. Can't wait to get home, and I'll take it. So I got home, and I took it. First one I took was the white-black race. and I had a strong anti-black implicit bias. And I was stunned by it. So I waited a couple days and I think did what any lawyer or judge would do, so I took it again. And I had a strong anti-black implicit bias. And then I waited another week or two and it was kind of eating away at me and I took it a third time. And I had a strong anti-black implicit bias. So I did, I think, what any lawyer or judge would do. I assumed the test was invalid. And so this was 12 years ago, so you could actually read everything written about on the test back then. So I read everything I get my hands on. I even called two of the three inventors of the IAT and had long discussions with them. And you know, everybody has to decide for themselves, but I came to the belief that the test was valid, and the problem was not with the test, but with me. And that's what got me interested in the scholarship and understanding of implicit association, and has prompted me to do a number of things that I do differently than all the other judges, including I was the first judge in the country to give a jury instruction on implicit bias. I've given it in every trial in 5 different jurisdictions over the last decade. So for those of you who haven't been on Project Implicit, it started at Yale University in '98. It's now at Harvard, Virginia, and Washington. 2003, it took off with a federal research grant. That's an old slide. It's actually 15 million tests since 1998. It averages, actually, probably that's closer to 25,000 per week. You can go to the website, just put Project Implicit into your search engine of choice, and it'll take you to the website. There's probably 70 or 80 different implicit bias tests that you can take. So it's a virtual laboratory. You can test for virtually anything you want. That's just some of the more popular tests. That's what it looks like, and you just click on it. This is what they report on their website, some of which I agree with, some of which I don't. Implicit biases are pervasive. I agree with that. People are seldom aware of their implicit biases. I disagree with that. I think unless you've taken an IAT or have some reason to have studied implicit biases, nobody's ever aware of their implicit biases until you take a test and find out what they are. Implicit biases predict behavior. I strongly disagree with that. Implicit bias sometimes predicts behavior. If it never predicted behavior, you all would be here, but I wouldn't be here talking to you about it. The only reason why I'm interested in it is because it sometimes predicts behavior, but not always. And so that's really the big wrinkle. People differ in their levels of implicit biases. If everybody in the room took 25 different IAT scores, I'm fairly confident that your profiles would not be identical. Some would be similar, but they'd be somewhat different. It's kind of like a snowflake. If you take enough IATs, you're going to have a different profile than somebody else. There's a current controversy over the validity. Whoop, I typed that just a few minutes ago. You can see how good my typing is. It should be IAT. And I wanted to mention the controversy. I usually don't. There are a small group of law professors and cognitive psychologists who have criticized the validity of the IAT. I'd say of people who look at it, and I read virtually, I spend a lot of time reading every new study and certainly the criticism of the IAT. I side with the side that says it's valid, which would be about 95%. You know, it's not a popularity contest. But here's the deal. Let's assume that it's invalid. Let's just assume that. And it doesn't accurately measure your implicit biases. Even the folks who criticize the IAT, they've never suggested implicit biases don't exist. It's just, it may not be an accurate way of measuring it. So everything I say, I think we can assume the IAT is invalid because that's just a measurement tool. It doesn't mean we don't have implicit biases. So in order to actually understand implicit bias, you need to understand some psychology principles. So I'm going to cover these as quickly as I can. This was a best-selling book by Daniel Kahneman, a Nobel Prize winner, on thinking fast and slow. And here's just a little simple diagram. So as lawyers, and I'll pick on lawyers, we all engage in System 1 and System 2 activity every day. System 1 would be, for example, when I'm in court and somebody makes an objection, violates the confrontation clause, I have two choices, overruled or sustained. I have to do it quickly because we have to move on with the trial. That's a system one. I don't have time to think about it. I don't have time to pull up legal research on my computer on my bench, instant message my law clerks and say, what do you think? I mean, I just rule. That's system one. System one is a richer environment for implicit biases to affect decision making. System two would be when I write an opinion, so I have time. It's still possible that implicit biases affect your opinion, but it's a little bit less likely because it's slower, it's conscious, it's effortful. So I like little diagrams. So bias can be explicit, which is conscious and intentional, or unconscious and automatic, which is implicit. Oftentimes they exist in tandem. So this is a really important concept to understand in-group favoritism. We all engage in in-group favoritism. Don't fool yourself. It's almost in our DNA. I'll give you an example. Until I started studying implicit bias and my in-group favoritism, when I get about 400 applicants for one law clerk position each year. And if I see somebody that went to, I was what they call well-traveled in college. I went to 5 different colleges, all in Minnesota. So if I see somebody that went to one of the 5 schools that I went to, or maybe played college tennis like I did, or grew up in the Twin Cities where I grew up, wow, that's somebody I'm interested. And I did that for a number of years, but once I started getting involved in implicit bias, I mean, it's so simple. What does any of that have to do with their qualifications to be a law clerk? Well, they went to Drake Law School. I went to Drake Law School. I should hire them. What does that have to do with anything? Nothing. Has nothing to do with their qualifications. And think about your own decisions that you make with regard to roommates or people in your study groups or people you socialize with. Most people tend towards in-group favoritism. So here's another one of my simple diagrams. There's this concept of in-group favoritism on the one hand and out-group hostility on the other. And so I think it helps people understand implicit bias better. You don't have to have out-group hostility towards blacks to have a strong anti-black implicit bias. I mean, I am a good example of that. I have no outward hostility, but I engage in in-group favoritism, I think, as we all do, and I try and struggle with it. They're now developing tests to figure out, with regard to an implicit association test, whether, let's say, an anti-white bias, whether that comes more from in-group favoritism or comes more from out-group hostility. So that's kind of an exciting development. So in-group favoritism, positive emotions like admiration, sympathy, and trust, positive actions in hiring, promotion, positive references, reserved, but it's reserved for in-groups and withheld from out-groups, and it leads to bias and discrimination. So there's a great article on in-group favoritism. Anthony Greenwald, the lead author, he's one of the 3 people who invented the implicit association test. And he wrote, our strong conclusion is that in present-day America, discrimination results from helping in-group members more than harming out-group members. So now I want to talk to you about my favorite subject, priming and stereotypes. So this is a study that was done back in 2008 when President Obama was running. And they gave IATs to people, and then they took people who had a strong anti-black implicit bias, 2 standard deviations above the mean, which would be where I score on an IAT from 12 years ago. If I took one this afternoon, I'm fairly confident I'd have the identical score because it's never changed. And then they showed people a Photoshop light-skinned version and a Photoshop darker-skinned version of President Obama. And voting for President Obama increased 18% when they were primed. The likelihood that they would vote for President Obama increased 18% when they were primed with the light-skinned Obama. This is a great study by the middle author, Marizan Banaji, is one of the other 3 inventors of the IAT. She's a professor of psychology at Harvard. And they went and bought a bunch of baseball cards that were fairly valuable. And they had cards that were in the same condition. And then they put them for sale on eBay. And the independent variable is the color of the skin, color of the hand holding the card. And if it was a black hand, it sold for 20% less across the board than if it was a white hand. So people are subconsciously primed by the color of the hand. There was another one done on gender, where they put kind of male considered automobile tools like a jack and other tools related to cars. And if the eBay ad indicated it was being sold by a female versus a male, it brought 25% less in terms of what people perceived as the value of it. So stereotypes can be triggered by very subtle primes. We're primed all day long in our lives. This is my favorite priming study. It was a study done of 1,000 Harvard entering freshman students, and it involved an email address from a fake student, Amy Chen. So a third of the students, the email address that they received the email from was Chen, harvard.edu. That's what I call the Asian prime. A third of them got Amy, which was the gender prime, and a third got AC, which is no identity prime. They had a series of emails going back and forth with these entering students, but in the very first email, the sender of the email indicated that their SAT scores was 730 quant and 720 verbal, and they had emails going back and forth, and then about 10 days later, they asked all the students if they could remember the SAT scores from the first email that they received. If they received the Chen, which is the Asian prime, they remembered the quant score significantly higher than it actually was. If they received the Amy gender prime, they remembered the quant score significantly lower than it actually was, but the verbal score significantly higher, along with kind of traditional stereotypes. And if they just received the AC, the no identity prime, they much more accurately remembered the actual SAT score. So I think that's a great example of priming. So I'm going to talk about this towards the end. This is actually my favorite study. It's done by Justin Levinson, who's a implicit bias scholar at the University of Hawaii Law School and the co-author of a couple of articles that we've done together. And the only difference here is using Photoshop. You notice the one on the left has light skin and the one on the dark has black skin. And the results of the study participants looking at ambiguous pieces of evidence, dramatically different based on whether they were primed with a light skin or dark skin photo of the alleged robber. So we'll come back to that. So I want to talk to you about blind spot bias because we all have them, almost all of us. And there was a great book written about blind spot bias. It's really written for the general public, and it's by two of the three inventors of the IAT, Dr. Bernanke and Dr. Greenwald. And it was actually mentioned in, he didn't mention it by name, but Justice Kennedy defined it about as well as anybody can define it in a case called Williams versus Pennsylvania, involving a justice of Pennsylvania Supreme Court who was a local prosecutor, prosecuted a defendant, and both he and the defendant wound up in the Pennsylvania Supreme Court. And the question was, did he have a duty to recuse himself because of a conflict of interest? He didn't see the conflict. He didn't recuse himself. Goes to the United States Supreme Court. Supreme Court says, yes, he had a duty to recuse himself. And Justice Kennedy wrote this great sentence: bias is easily attributed to others and difficult to discern in oneself. And that is the blind spot bias. So back in 2009, Jeff Raklinski, who's a psychologist and law professor at Cornell, did a study of state court judges in New York. And he asked them to rate their ability to avoid racial prejudice in decision-making compared to other judges in the room. He had about 120 judges. And 97% rated themselves in the top half. Does that surprise anybody? I mean, I'm not very good at math, but that's a little funky. So I decided, I was actually working on a footnote for a law review article at Yale. So I decided to do this, repeat the study, just a couple of twists to it with regard to federal judges. And then at the last minute, I added probation officers. So I did this a year and a half ago. And I broke it down by senior federal district court judges. They had the highest blind spot bias, federal district court judges, then Article I judges, magistrate judges, federal bankruptcy judges, and then at the last minute I added 5,000 probation officers. I was very surprised that probation officers had the highest blind spot bias, and I asked them to rank themselves in the top 25% of respective colleagues' inability to make decisions. One question was on race and one was on sex. So, you know, I don't mean to pick on judges or probation officers. I assume if I gave that to everybody in the room or did it to the general public, people just have this blind spot bias. We see that other people make decisions that are discriminatory, but we don't see it in ourselves. So it's important to recognize that we have blind spot bias. So here's kind of a study that combines implicit white favoritism with racial priming. So in this study, the participants were divided into 3 groups. They either got the black face, the white face, or the squiggly lines. But it was subliminal. And what that means is they saw it for, I don't remember, I think it was 0.023 of a millisecond. So it was flashed on a computer screen. If you were to ask them, what did you just see? Nobody could tell you. They couldn't tell you it was a black face. They couldn't tell you it was squiggly lines or a white face. And then they were asked to identify what the scholars doing the study, crime-relevant objects like handcuffs, knives, guns, and then crime-neutral objects, an iron. Now, in federal court, I've never had a case with an iron, but I bet state court judges have. You know, iron can inflict plenty of damages. So that's the difference between an academic and a practitioner, I guess. So they're asked, what they were asked to do is, when could you identify the gun, for example? So that's kind of what frame 1 looked like. By frame 20, frame 41, you can definitely see it's a gun. So here's the results. And the important thing is to look at the white bar. And so when they were primed with a white face, again subliminally, it took them 27 frames before they could identify the gun. When they were primed with the squiggly lines, they could identify the gun in about 23 frames. When they were primed with a flashing black face, they identified the gun in 18 frames. So just the subliminal priming allowed them to identify a crime-relevant object much more quickly if they were primed subliminally with a black face. This is another study done with ape images, again priming with black faces and white faces, and it's the same thing. And in both studies, it goes both ways. Not only does it take them longer to identify a real ape or a real gun if they're primed with a white face, but when they're primed with a black face, they do it much more quickly. So I think it's interesting, implicit bias in children. This was a picture I just saw in the news a couple of weeks ago about this young child dressed in a Ku Klux Klan outfit. I don't know what parent would do that. So I was really interested in it. So the picture is actually like 20, 25 years old. But it's interesting, when do we develop our implicit biases? So that's been studied. This is another study by Dr. Banaji. At age 6 years old, implicit biases are pretty well set. They tend not to change as we get older. But the good news is our explicit biases decrease with experience and age. There's a really interesting new study done with preschool children, ages 3 to 5, in both China and Africa. And what they did is they found medium-sized cities. The one in China was 99% Han Chinese. And then they developed a new IAT for 3, 4, and 5-year-olds and asked them explicit bias questions and then gave them the IAT, gathered some demographic data. And all the kids in China were Han Chinese. And presumably, they had never actually met a black person and very, very few white people. The Chinese students had very strong in-group favoritism and very strong anti-black and anti-white bias. And then they did the identical study in a small city in Cameroon. And the reverse, you know, the black kids had strong in-group favoritism and strong anti-Chinese and anti-white bias. So I want to talk a little bit about the emerging neuroscience of implicit bias, because I think there are some doubting Thomases in the room, and that's great. And people who have taken the IAT and you don't buy into your results because you can't believe you have anything to do with racism. But the neuroscience is really interesting, and it involves MRI and fMRI machines. And so when an fMRI is nothing other than an MRI machine, but you're asked to do something when you're in the machine. I was in an MRI machine for 2.5 hours at Vanderbilt Medical School, and they asked me 200 hypotheticals about crime and punishment. Then my fingers were wired with Velcro, and I had to decide how serious I thought the crime was and how serious I thought the punishment should be. And so they've done, there are 3 parts of the brain that are related to implicit bias: the amygdala, the dorsolateral prefrontal cortex, and the insula. I'm condensing a 4-hour presentation into about 45 minutes, so I'm only going to talk about the amygdala, which is the most important part. That's what it looks like. It's bilateral. It means on each side of the brain. It's almond shaped. That's what the Latin word amygdala means, almond shaped, and it's our fear center. So whatever fears that you have, they're triggered biologically in the amygdala. You may be afraid of heights. You may be afraid of spiders. You may be afraid of law professors. You should be afraid of federal judges, but not state court judges. Whatever your fears are, it's the amygdala that registers, and it comes from all parts of the brain, but it gets centralized in the amygdala. And that's what amygdala fMRI activation looks like. So there are now dozens of studies, and they're primarily about facial recognition. So originally, they just shove a Caucasian into an fMRI machine, and then they show them pictures of faces of other Caucasians and black people, and then they measure the amygdala response. And so, of course, this is very general. I'm not saying everybody, but in general, if they're shown white faces, there's no amygdala activation. But if they're shown black faces, these aren't scary pictures. They try and pick. I've seen the pictures that they actually use, and they're emotion neutral. You know, they're neither happy, or sad, or glad, or mad. They're just kind of ordinary facial expressions. And so the original research was just with whites, and then somebody got an idea, well, let's actually put African Americans in fMRI tubes. And they got different results than they did with whites, just like on the IAT. 85% of Caucasians who have taken the IAT have a mild or strong anti-black implicit bias. Of African Americans who have taken the race IAT, it breaks down about a third anti-black, a third pro-white, and a third neutral. And that was true in the amygdala studies as well. There's a strong relationship between amygdala activation and IAT scores. And so if the IAT, I realize this is inferential reasoning, but I had a discussion with the gentleman in the front row, I'll single him out, who is convinced the IAT is invalid, and that's fine. I'm surprised there are so many studies that show such a strong correlation between like amygdala activation and an IAT score. I realize it's a correlation, not a causation, I get that. And there's no correlation with express measures of racial bias in the amygdala studies. Skin tone is something I've become very interested in Afrocentric facial features. The darker the Afrocentric facial features, the longer your prison sentence is going to be, the higher your bail is going to be. At every pinch point in the criminal justice system, if you have darker skin or stronger Afrocentric facial features, you're at a distinctive disadvantage. I'm fairly confident that's a result of implicit biases. So quickly, just some social science research. There's a really interesting study that was done on orchestras. They looked at the top 5 orchestras in the United States. This is a gender study. And they figured out that there was a very low percentage of females who auditioned who ever got jobs in the 5 major orchestras. Somebody got the bright idea of, let's have them do it blind behind a curtain. So the 5 major orchestras set up curtains. They had the auditions blind. The number of women hired did not go up initially. Somebody figured out the reason why. Women wore high heel shoes to the audition, and when they walked across the stage behind the curtain, almost always it was 2 males that were making the decision, the orchestra conductor and the symphony head honcho. And subliminally, the clicking of the heels signaled that it was a female, and the rate didn't go up. Once they asked the females to wear flat shoes, the hiring over a period of years went up 8-fold. Okay, this is a great study. It's it's a very famous study done by two labor economists. Are Emily and Greg more employable than Lakeisha and Jamal? So they looked at want ads in Chicago and Boston, about 200 employers, and they had phony resumes, but of really highly qualified people, kind of middle qualification and low qualified, and the only independent variable was the name that they used on the resumes. They sent them to real companies with real want ads in real newspapers. Not much of that exists anymore. Real want ads had newspapers, but it did in 2004 when they did the study. And so that was the only independent variable. They set up a phone bank to see who would call to set up an appointment. And you can guess the punchline, that's the callback rate. The callback rate was 150, almost doubled, not quite, if they had white-sounding names rather than black-sounding names. That study has been repeated a number of times with the identical results. So I'm going to pick on physicians for a while. This is a good study. Physicians at 220 internal and emergency residents in Atlanta and Boston were studied, and they were given a hypothetical, a clinical vignette. Mr. Thompson, 50-year-old, presents with sharp stabbing chest pain. Half of them were told he was African American, half were told he was white. They were then asked in random order a bunch of explicit bias questions. They were then given an IAT, and before that, actually, they were asked whether or not they would prescribe very expensive thrombolytic clot-busting drugs. Good news is the doctors had no express biases. The bad news is there was a strong correlation between their IAT score and whether or not they decided to prescribe a thrombolytic drug. Jury studies, there are several, none actually of real jurors, but jury eligible folks. So I only have time to talk about my favorite study on ambiguous evidence. This is back to this crime scene photo again. Remember, the only difference is the color of the skin. This is a study done by Justin Levinson at Hawaii. Danielle Young is a psychologist. She was at Hawaii. She's now at Manhattan College. And here's what they did. The subjects viewed 5 crime scene photos of an armed robbery at a quick stop mini mart. The only difference was the one photo I showed you. Everything else was identical. They were then given 20 pieces of ambiguous evidence, and then they were asked to decide, is the defendant guilty or not guilty based on these 20 pieces of ambiguous evidence, which I'll describe in a minute. And then Justin and Danielle did something fascinating, which I'm actually doing now in a real study that I'm doing in my real trials. And that was, they asked the jurors, well, how guilty is the defendant? That's not a concept we think about. We do it binary, guilty, not guilty. But they asked on a scale of 0 being not guilty and 100 being guilty, how guilty was the defendant based on the 20 pieces of ambiguous evidence. So let me give you an example of how they interpreted the ambiguous evidence. They were told that when the defendant was arrested, he had a movie ticket in his pocket. And the movie, if he had actually attended the movie, he couldn't have robbed the mini mart because he was quite a few miles away, and the length of the movie made it impossible for him to be the robber. If they were primed with the black skin forearm, here's what the deliberating jurors said. Well, he must have bought the ticket to create an alibi. If they were primed with the white skin photo, he's obviously not guilty because he wasn't at the mini mart. In the photo, the defendant is carrying the gun in his left hand. They were told one of the pieces of ambiguous evidence was that the defendant was right-handed. If they were primed with the black skin, he obviously held the gun in his opposite hand so that it would create a defense if he was ever caught. If they were primed with the white skin, it's obviously not the person in the photo. He can't be guilty because he's right-handed rather than left-handed. So they interpreted ambiguous evidence based on whether they were primed with black skin or dark skin. They published the results of the second part of the study in a second law review article. How guilty was the defendant? If they were primed with the black skin, the defendant was very guilty. If they were primed with the white skin, the defendant was primarily not guilty. Warm feelings towards blacks actually increased implicit biases on the black guilty IAT, and there's a significant correlation between black and guilty and white and not guilty on an IAT. There are only 2 studies of judges where they've actually given the judges IAT tests. The one study was done by Jeff Roklinski, again at Cornell. It was done in 2009, published in 2010 in the Notre Dame Law Review, and he looked at state court judges that were at conferences in the West Coast, the middle part of the country, the East Coast, gave them a bunch of, mostly they were juvenile court judges, gave them a bunch of hypotheticals about should the juvenile be adjudicated guilty, and if so, what the punishment should be, and gave all the judges IAT tests and other demographics. And one of the primary findings of the study was that judges have stronger implicit racial biases than members of the general public, but for the most part, particularly the black judges, were able to control their implicit biases. The white judges, to a certain extent, not so much. It's a very complicated study. So we did a study, Justin Levinson and I, and our statistician from Japan, and it's called Judging Implicit Bias, a National Empirical Study of Judicial Stereotypes. Kiyoshi Hayoki is a Japanese statistician, teaches at a college in Japan, and he helped us with our statistical work. We created several new IATs, and we presented a white-collar scenario. We picked Asian and Jewish. I actually took a white-collar case that I had, and then changed the pre-sentence report, used a lot of the same information. But we wanted to study both state judges and federal judges because that had never been done together. We picked Asians and Jews because, one, they're not studied very often in terms of implicit bias, and they're considered privileged minorities. And so I created this pre-sentence report. It's very difficult to create a report that you can use with federal judges and state judges because every state some have sentencing guidelines, some don't. Federal judges do. So it took a long time to come up with the pre-sentence report. I used focus groups of federal judges, focus groups of state court judges to make sure they could understand the pre-sentence report. And then I used a random state court generator. I just went into Google. I didn't know if one existed. So I Googled random state court generator. A bunch of them popped up. I said, give me 15 states. It kicked out 15 states at random. Those were the states we used. I wrote a letter to the Chief Justice of each of those states. And I didn't want them to know exactly what we were studying, so I said we're just doing a study on sentencing, differences between state and federal judges. They all said, great, you can contact our judges. But then there was a little wrinkle in it. Everybody is so concerned about computer security, and they should be. In order to do our study, and one of the criticisms of the IAT is everybody that uses their own computer has kind of a different bandwidth when they connect to Project Implicit website. So the algorithm that they use is pretty wide. Well, we wanted to overcome that problem, so we got a download that takes the algorithm we use and factors in the speed of so that the speed of your connecting to the website that we created couldn't affect the results. And when I got them on the hook first, but then when I told the 15 Supreme Court justices, oh, by the way, the judges have to download this little add-on, it's not a problem. I had a letter from a guy who invented the piece of software. They've never had a problem with it, but 7 of the states dropped out. I understood that. So we went with 8 states. We created customized IATs. Judges got either the Christian defendant, the Jewish defendant, the Asian defendant, or the Caucasian defendant. Everything else in the pre-sentence report was the same. There were a couple of minor differences other than the names to kind of make it more credible, but the independent variable was basically just as I described. So I'll show you our results. I thought I'd show you our results. Here we go. Judges implicitly biased against Asians. Federal and state court judges strong to moderate implicit bias against Asians relative to Caucasians. Asians were associated with negative moral stereotypes, greedy, dishonest, and scheming. Caucasians were associated with positive moral stereotypes, trustworthy, honest, and generous. The same thing with regard to Jews, it's identical, so I'll skip that. All judge cohorts, we actually looked at federal district court judges, senior judges, we threw in magistrate judges, and then the judges from 8 states. All judge cohorts possess similarly strong implicit biases, stronger than members of the general public, significantly stronger in some cases. A political party of the appointing president did not predict different IAT scores, so that's positive news. I've done 4 empirical studies of my colleagues, and I never ask what president appointed them because I'm offended when people ask me that. So we just ask them the year, and then we have a little software piece that figures it out. It's 96% accurate. In any given year, if the president is Republican, 95, 96% of the judges will be Republicans. Judges' self-reported agreement with Asian stereotypes were correlated with their agreement with Jewish stereotypes. Anti-Jewish pro-Christian implicit biases predicted the length of sentence of the Christian defendant. The higher the bias, the shorter the sentence. So I want to talk to you now about Afrocentric facial features real quickly. So here you see the person on the left, they have strong Afrocentric facial features. I'm sorry, the person on the right. Person on the left, not so much. So if I were to give you, there's actually social science, a lot of data on what it means to have strong or not so strong Afrocentric facial features. They look at 9 facial characteristics. If I were to have 9 pictures from lowest to highest in Afrocentric facial features, shuffled them up and gave it to everybody in the audience, 92% of you would be able to put them in rank order. It's not really very difficult. The bottom line is, as I mentioned, at every pinch point in the criminal justice system, if you have darker skin tone or stronger Afrocentric features, watch out. You're going to get a longer sentence using regression analysis. So I wrote a short article for Yale. They invited me to write a piece back last November or so. It was published, I think, in January, where I talked about Afrocentric facial features and skin tone bias being the next frontier of sentencing. And then that short piece got me a little bit more interested. So I worked with a psychologist at Berkeley, also a law professor, Victoria Plout, and we're publishing our law review article. It should be out in January. We actually traced Afrocentric facial feature bias back to the Civil War. We looked at the literature at the time, medical research at the time, a bunch of different factors, and we concluded something that I always thought since I've gotten involved in this, that minority defendants, particularly African American defendants, particularly male African American defendants with a darker skin tone and stronger Afrocentric features, not only do they not benefit from the presumption of innocence, but there's actually a presumption of dangerousness. There's been only 3 studies of Afrocentric facial features, and I'm sorry, there've been 5 studies. One was done by Jennifer Eberhardt at Stanford, and she looked at 600 death penalty cases in Philadelphia. If you just look at the top, with a black defendant, white victim, if the tall black line represents strong Afrocentric facial features and darker skin, you were twice as likely to get the death penalty if you had strong Afrocentric facial features and dark skin. Just very briefly about the biasing, stereotype mindfulness, be mindful of your stereotypes. We all have them, so figure out when you're stereotyping and when you're not. Use counter-stereotype imaging. For example, Martin Luther King is my hero. I have his famous quote, the arc of the moral universe is long, but it bends towards justice. I have that in my chambers. I have it on T-shirts. I have it on coffee mugs. I actually have it in calligraphy in the bathroom, so when I get up at 3:30 in the morning to go to work and flick on the light, the first thing I see is Martin Luther King's quote, and it's the last thing I see when I leave my chambers. So when I go into court and I see most of our defendants, 55% of the defendants I sentence are minorities, so I always do counter-stereotyping. When I walk in and I see a very dark-skinned, strong Afrocentric facial feature defendant, I always take a minute and relax and think about my hero, Martin Luther King. That's an example of counter-stereotype imaging. Be empathetic, perspective, try to take the perspective of the person you're making the decisions about. Make sure you do individualized decision making, and seek out-group, yeah, that should be seek outer group contact, not out inner group contact. And so there's actually no empirical evidence that any debiasing technique works. And there's starting to be now pretty substantial meta-analysis of debiasing techniques. And while I think it's important to try and do all the things and do what you can, and I have a fairly lengthy discussion with jurors about implicit bias, and I actually show them about 2 different videos, and we discuss it. There's no empirical evidence that any debiasing technique works. Hopefully there will be, but there really isn't yet. So I'm going to end with my favorite quote. The arc of the moral universe is long, but it bends towards justice. The thing of it is, it doesn't bend on its own. So each of you in the room, no matter what you do, you have an opportunity every day to put your hands on the moral arc. I hope you bend it towards justice. Thank you very much. Any questions? Do we have time for any questions, Dean?
We do. I think some people...
If you have to leave and go to class, go. Be happy to take questions if anybody have any.
Well, that's going back, maybe I'll just ask mine. But when, I should use the to a microphone here, right? When I saw you talk before, you were talking about folders that you get, sentence and reports and pictures.
Yes.
Just tell the group a little bit.
Sure. Well, yeah, it's true in state court. I think it's true in every court, particularly on felonies. We get a very detailed pre-sentence report. We have 28 United States probation officers. We're very busy on our criminal caseload, and they prepare a very detailed pre-sentence report. About 15 years ago, somebody in the country got what they thought was a great idea. I did too at the time. Let's put a picture of the defendant on the front of the pre-sentence report. And for me, the vast majority of defendants I sentence, the first time I see them is when I walk in the courtroom to sentence. I don't take guilty pleas. Our magistrate judges do. I don't do suppression hearings. Our magistrate judges do. I only do an initial appearance if a magistrate judge is out of town. So unless they've gone to trial, 99% of the time, the first contact I have is when I walk into the courtroom. Except actually the first contact is when you look at the pre-sentence report. And when I started understanding the effects of priming, I decided I don't want to be primed by a picture. And so I determined what I think an appropriate sentence should be before I see, before I have a physical image of the defendant. And then when I go into court and listen to the arguments of the lawyers, if I change my opinion about what the sentence should be, I do kind of an implicit bias gut check. Is there an objective reason about why I have a different view of the defendant than I had when I walked in the courtroom, and now I see that it's an African-American male with very strong Afrocentric facial features and very dark skin. What is my objective reason for going higher? Or if I now see a very attractive female and I'm going lower than what I originally thought, am I doing it because of reverse gender bias? Or is there some objective reason about why I'm going to give a lower sentence unrelated to the physical characteristics of the defendant? So that's my spiel on that. Any other questions? Yes.
Judge, thank you for a really powerful presentation, and you covered a lot of different information.
Did I pay you to say that?
You did
okay,
not.
Thank
no.
you.
Although, my first comment, which was going to segue to my question, was that in some ways I was a sympathetic audience. So I'm a father of a number of kids, and so when I'm raising the kids, I know that at an early age, what I train them in is going to lead to how they act later in life, even if they don't necessarily recognize it. And I'm also a follower of virtue ethics, and virtue ethics assumes that humans operate based on heuristics that once we get older, we don't even know about them anymore because we develop them so early. But that also then, I want to present you with an opportunity to respond to one of the criticisms of some of the claims you made today. And so one of the criticisms that I came across in preparing for your talk was that the authors of the IAT test have themselves, since they've done a meta-study of 122 studies of the efficacy of the IAT test itself, and they themselves concluded that it has a 5.5% correlation between the results in the IAT test and predictability of real-world discrimination, which I don't want to discount. That's not nothing, right?
Right.
But that's not as powerful as one might get from the presentation you gave. And their summary in 2015 was, quote, it renders the IAT test, problematic to use to classify persons as likely to engage in discrimination. So I want to see what your response was to that.
Yeah, I'm familiar with that. Thank you for doing homework and preparing. I really appreciate it. So my response is, and I think I already indicated, let's assume the test is not valid. None of the criticism that have been addressed to the IAT ever suggests we don't have implicit biases. It just suggests that it's not a very effective measurement tool. So I don't use an IAT for any purposes other than in the empirical studies. I mean, after I wrote my first law review article, some law professor came out with the idea we ought to give jurors IAT tests and make that available to the judges and the lawyers. That's ridiculous. So I'm not suggesting we should use IATs for anything other than perhaps self-awareness. And that's so, but I continue to use IATs in empirical studies. I've got one now involving, that I'll just tell you about because I've got the preliminary data. The stereotype is that females suffer greater emotional distress based on the same harm or injury. That's the stereotype. So I created a couple of different fact patterns involving emotional distress only, and we had a bunch of lawyers and quite a few judges take it, and we're looking at the independent variable was gender, so we used a gender-neutral name like Pat Smith, but then we used gender pronouns to describe the person and what happened to him, and so lawyers thought the case was less valuable with women than they did men, and judges awarded lower emotional distress damages on the identical fact pattern when they were told it was a woman rather than a man. And then there's a very strong correlation between the IATs. So, I don't really know what to make of it. I think it's fun to use it to study things. Is it the be-all, end-all? No. So that's the best I can do. And hopefully, particularly with the critics of the IAT, they'll come up with something better that proves to be, more accurate. So that's a great question. Thank you so much for asking it. I'm not here to defend the IAT. And I'm certainly not objective about my view of its accuracy because I'm friends with two of the founders of it, and that shapes my judgment. I mean, that's a heuristic we all share. So, good, great question. Anything else? Yes.
So I as well would like to thank you.
Wait for the microphone so look at you.
So I as well would like to thank you so much for coming, and I think it was a powerful lecture as well. But I would like to know, how do we make a change if this is arguably making such a big impact on sentencing and I think I would call injustice to certain groups. How do we make a change?
Yeah, that's a great question. How do you make the change? I think the number one thing is awareness. And so I had a really interesting conversation with a brand new judge in Minnesota. He was a Justice Department prosecutor at Main Justice DOJ in Washington for a number of years. Now he's a brand new state court judge in Hennepin County. And he's developed what he calls his implicit bias bench card, and he has it laminated. It should be back at my chambers when I get there. And it's things like, slow down. Do I have a stereotype about this defendant? If so, what's the stereotype? Where does it come from? What relationship does it have to do with anything? He's got a whole list of about 10, 11 things. And it just helps them be conscious of the potential for implicit biases to sneak in. And so that's a good example of what you can do. Slow down in your decision making. Be mindful of the role that subconscious bias can have. and try and make the best judgments on objective pieces of evidence. And that's about the best thing I know of to do it, to handle it. So thank you. Any other questions? Okay, well, you've been a wonderful, oh, yes.
Thank you very much. I just wondered if you thought there should be more widespread jury instruction to jury members in regards to implicit bias.
Yeah, I definitely think so. But I think the instruction alone is not enough. And so, I mean, I do a lot in terms of jury selection. And I also tie it into the presumption of innocence because it's real interesting. There isn't a single study out there, and there are lots of them, that indicate that jurors understand the presumption of innocence instruction. As a matter of fact, every single study ever done indicates that jurors do not understand the presumption of innocence. So, for example, there's a recent study in Wyoming. They have a fine pattern reasonable doubt and presumption of innocence instruction. But when they interviewed the jurors afterwards, 55% of the jurors thought that if the state put on any evidence, anything, one witness, one document, then the burden shifted to the defendant to prove that they're innocent. That's how they interpreted the reasonable doubt instruction, the presumption of innocence instruction. So I do something. I put the instruction up on the big screen so all the potential jurors can see it. And then I ask this question. And when I did criminal defense, I learned it from a really terrific African-American trial lawyer in the 70s in Des Moines, Henry T. McKnight. And I watched him try several criminal cases. He would just pick on a prospective juror, and he'd have his client stand up, and he'd say, "What do you think about Mr. Jones here? Is he not guilty or guilty?" And the jurors would always say, "Well, I don't know. I haven't heard any of the evidence." And then he'd walk over to the prosecutor, and he'd put his hands on the prosecutor's shoulders, he or she, and then he'd say, "You've just done half of the prosecutor's job for him," because the only acceptable answer is not guilty. So I do that. I've done it every trial. I ask usually 7 to 8 prospective jurors. This is after they've seen my presumption of innocence instruction. What do you think? Have the defendant stand up, take a good look at him. Is he guilty or not guilty? Only once in 23 years in some 150, 200 criminal trials have I ever had a juror say he's presumed innocent, so the answer is he's not guilty. So about 8 years ago, I got really tired of hearing "I don't know" in response to that question, because they should be saying, well, based on your instruction, he's not guilty. So I'm pretty spontaneous, and so I was trying my typical methamphetamine drug conspiracy case of the week involving a Hispanic defendant. Mr. Rodriguez, would you please stand up? What do you think? Not guilty or guilty? I always say not guilty first. Everybody said they didn't know because they hadn't heard the evidence. I got up off the bench. I walked across the courtroom. I put my hand out to Mr. Rodriguez. He stuck his hand out. He was surprised. Nobody knew it was coming, including me. I grabbed it with both hands. I shook his hand, and I turned to the 31 prospective jurors, and I said, I just shook hands with somebody who is absolutely not guilty unless and until the government can prove him guilty beyond a reasonable doubt. Some of you may not believe that, and that's okay. But here's the deal. See the 2 exits? Please stand up. You're excused from jury service because you're not serving on this jury. It's very powerful. And the reason why the handshake is powerful is when the jurors come into the courtroom, I'm not on the bench. I'm at the door that they come in, and I don't wear a tie, and I don't wear a suit. I just have a shirt and a collar on, and I shake hands with each of the potential jurors, just like I'm going to do in about 30 minutes with the defendant. I say, thank you. Hope you have a good experience. Thanks for coming. Good to see you. Hope you enjoy jury service. They don't know I'm the judge. They don't know I'm the judge because I've removed all the portraits of all the white judges from my district going back to 1860 and took them out of the jury deliberation room and we put in pictures of new citizens of every shade of color imaginable, because there's some evidence that that might help with implicit bias. And then I run down the hall, put on my robe, and I walk out on the bench, and they're all, you know, he wasn't the Walmart greeter that they hired to greet everybody. He's the judge. And so I'm actually doing an empirical study of that right now, using Justin Levinson's 0 to 100 measurement. So I use a random selector for each criminal trial. And so what I do is, after they see my jury instruction, and I say, is he guilty or not guilty, and they always say, I don't know. Half the time, it works out half the time, but it's random, I pass out this questionnaire. It just says, as you sit there now, how do you rate the defendant, with 0 being not guilty, 100 being guilty? And then, so randomly, half of them get it before the handshake, half of them get it after the handshake. The only independent variable is the handshake. And so I have preliminary data from a number of trials, and it's very strong, indicating that the handshake dramatically increases their belief that the defendant is actually not guilty. I want to do another 6 or so criminal trials before I crunch all the data and write up an article about it. So, but then you know, this video that I show up is very powerful because it plays into all of the implicit biases that most of us have. And what it is I show a picture of a black man, and then there's a rap sheet. So armed robbery gets down to rape, and then it gets down to murder. And then I stop it. It's actually a video. And I stop and I just say to jurors, what do you think about the person in the video? He's terrible. They should have executed him after that rape. He never should have been allowed to commit a murder. I let the jurors just vent. I'll go through 5 or 6 of them. He's horrible. Then I hit the button on my computer and play the rest of the video. He's the arresting officer. They all assumed he was the defendant. And once I've had a juror say, well, how do we know the person in the picture is associated with that rap sheet? And when I first saw the video, I fell for it hook, line, and sinker. I just assumed it was the defendant because of my own implicit biases, I guess. So that's the thing I do. It leads to a great discussion about keeping it open-minded to all the evidence, the burden of proof, presumption of innocence, and it's a good opportunity to talk about why we assumed the person in the picture was the defendant. And it leads into a really interesting discussion about implicit biases. I confess some of my own implicit biases, so I let them know that I have them. And then they get this jury instruction about trying to rely on objective evidence, don't use stereotypes, gut instincts, etc. And not only do they get that in the jury room, there's a poster on each of the 4 walls that repeats that instruction and that language so that they see it during deliberations. And they're reminded of it. They each have an individual set of instructions, and they get to take that. They have it throughout the trial because I instruct at the beginning of the case, not at the end. And so they have that instruction for the whole trial. So, thank you. Anything else? I'm over time. Yes?
How do you judge the validity of the test? I understand you have a very strong indicator of reliability. But how do you know that that mixes or matches with any set of behaviors in the world?
Well, like our study of the pre-sentence report, there was a very strong correlation between the IAT score on Asian Caucasian or Christian and Jewish and the length of the sentence. So what more could I have done? I don't know. If you've got a great idea, I mean, study after study, I realize correlation and causation are different. But study after study, there's a strong correlation between an IAT score and a decision. And so I don't know what else to do. But I'm willing to assume the test is invalid. It doesn't really change anything about what I do or why I do it. So I just talk about the test because it's the only one out there. But let's assume it's not valid. It's hocus pocus. The algorithm doesn't work. It's a fraud. So, okay, that means nobody says we don't have implicit biases. So, you know, for everything I do, I'm willing to concede the test is invalid. But my empirical research indicates there's a strong correlation with regard to Asian, Jewish, Christian, white, and with regard to gender and emotional distress damages. And so that's all I can do. I'm just a small town country lawyer. That's all. I'm doing the best I can. Thank you all very much.